12 cities. That is the number I kept finding when I cross-referenced the United States Geological Survey reports from the late 1880s against the property transfer records from the same counties in the same years. 12 American cities where the Federal Survey apparatus had documented the presence of oil bearing geological formations beneath populated land, and where, in the months and years immediately following the completion of that survey work, a pattern of land acquisition began that was quiet enough to avoid notice, systematic enough to suggest coordination, and precisely timed against the survey completion dates to make coincidence an inadequate explanation. Not timed against the publication of the survey reports, against the completion of the survey fieldwork. The window when the data existed in the hands of the people who had generated it, before it had been made public, before the landowners whose property sat above those formations had any way of knowing what was beneath their fields. I found this while researching the federal land distribution patterns of the post-Civil War era, trying to understand how the geological survey apparatus that the government had built to map the resource potential of the American interior had actually functioned in practice, whether the information it generated had flowed to the public it was supposed to serve, or whether it had flowed somewhere else first. I expected to find a story about the general dynamics of 19th century land speculation, the kind of activity that has always occurred wherever resource potential and information asymmetry exist simultaneously. Individual operators with good connections getting early looks at survey data and acting on what they learned before it became public. The kind of thing that is not admirable, but is also not particularly surprising given the era and the institutional environment. What I found was something more specific, more systematic, and traceable in the records that survive to a set of connections that points towards something more organized than individual opportunism. The official story of American oil development in the second half of the 19th century is a story of discovery, competition, and consolidation. Edwin Drake drilled the first commercial oil well in Titusville, Pennsylvania in 1859. The Pennsylvania oil fields generated a rush of activity that attracted thousands of independent operators. John D. Rockefeller recognized that the money was not in finding oil, but in controlling what happened to it after it was found. He built Standard Oil into a monopoly that controlled refining and pipeline infrastructure. The Standard Oil monopoly was broken by the Supreme Court in 1911. The story is taught as an American parable about industrial capitalism and its limits, about the creative energy of competition, and the dangers of its suppression. That story is accurate in describing the competitive dynamics of the oil industry's early decades. What it does not describe is how information about where the oil was located flowed from the government apparatus that was generating it to the private interests that were best positioned to act on it. The United States Geological Survey was established in 1879. By the mid-1880s, it had developed a systematic program for surveying subsurface geology across the continental United States. The survey teams mapped rock formations, identified structural traps, documented the presence of oil seeps and other surface indicators of petroleum potential, and submitted field reports to the Washington office that were eventually compiled into published bulletins. The published bulletins were public documents, available to anyone who knew they existed and knew how to obtain them. But the field reports were not published immediately upon their completion. There was a lag between the completion of fieldwork and the publication of results. A lag during which the information existed in the hands of the survey teams, the Washington office, and anyone connected to those sources who had reason to be interested in what the surveys were finding. Here is what the property records show in the 12 counties I examined most carefully. In each case, the pattern of land acquisition affecting parcels identified in the survey records as sitting above oil-bearing formations began not after the survey bulletins were published, but after the survey fieldwork was completed. in some cases months before the bulletins appeared. In all cases during the window between completion and publication. The acquisitions were conducted not by individual operators acting on tips from personal contacts within the survey apparatus. They were conducted through purchasing entities whose names appear repeatedly across multiple counties in multiple states during overlapping time periods. Entities whose corporate filings, where those filings survive in state archives, show connections to the refining and pipeline infrastructure that Standard Oil was simultaneously building in the same regions. The company that was controlling the movement of oil out of the established Pennsylvania fields was acquiring land above oil-bearing formations in states where oil had not yet been commercially produced. Before those formations had been publicly documented, using purchasing entities whose relationship to each other and to Standard Oil required multiple steps of corporate structure to obscure. Now here is where it gets strange. The families who sold their land in these transactions were not defrauded in any way the law of the period would have recognized. They were offered fair market value for agricultural land. They received that value. They signed documents transferring title. The transactions were legal. They were voluntary in the sense that no one was coerced. What made them something other than ordinary agricultural land sales was not any element of the transaction itself. It was the information asymmetry that surrounded it. On one side of each transaction was a family that owned land and knew it was agricultural land that could grow crops or raise livestock. On the other side was a purchasing agent who knew, from data generated by the Federal Survey apparatus, that the land being purchased sat above a geological formation that would prove to contain oil worth many times the agricultural price being paid. The family did not know that. The purchasing agent did. The Federal Survey had generated that information. And the Federal Survey's information management practices had allowed that information to travel from the survey apparatus to the purchasing agent before it traveled to the family whose land it most directly concerned. The geological survey records are in the National Archives. The field reports for the relevant time periods are there. What is not consistently present in those collections is the preliminary correspondence. The internal communications between survey field teams and the Washington office during the fieldwork period. The communications that would have established precisely when specific findings were documented, to whom they were reported, and through what institutional channels the information traveled between its generation and its eventual publication. In the counties where the land acquisition pattern is most pronounced, that preliminary correspondence is absent from the collections where it should be filed. Not damaged. Not misfiled in a location where it was eventually found. Simply absent. In a collection where the correspondence from the same survey teams covering adjacent counties with different geological results is intact. The correspondence that would have documented the chain between the survey findings and the land acquisitions is precisely the correspondence that is not there. The property records that document the acquisitions are in county courthouses. The names of the purchasing entities are in those records. The corporate filings of those entities are in state archives where the entities were required to register. The connections between those entities and the interests that funded them are traceable through multiple steps of corporate structure. What does not exist as a single compiled document is a comprehensive analysis connecting the geological survey data, the timing of land acquisitions, the corporate connections of the purchasing entities, and the subsequent oil production history of the parcels acquired. No congressional investigation has ever produced such an analysis. No federal prosecution based on the information asymmetry documented in those records has ever been brought. No academic study has traced the complete chain from the geological survey to the purchasing agents to the ultimate beneficiaries of the acquisitions. The Standard Oil investigation that produced the 1911 breakup focused on anti-competitive practices in refining and transportation, not on how Standard Oil and its predecessors had come to hold the mineral rights to land above formations they had known about before the landowners did. Maybe the acquisitions were the result of geological knowledge that the acquiring parties had developed through their own independent survey work rather than through access to federal data. Maybe the timing of the acquisitions against the survey completion dates is a pattern that appears significant but reflects nothing more than the general acceleration of land speculation activity during the same period when the Federal Survey was operating. Maybe the absence of the preliminary correspondence in the relevant collections reflects routine archival attrition rather than deliberate removal. Maybe the corporate structures used to conduct the acquisitions were standard business practice for the period rather than evidence of a coordinated program. I held all of those explanations as seriously as the evidence required, and the evidence required holding them seriously, because none of them can be definitively ruled out on the basis of what survives. But here is what I keep returning to. 12 cities. Communities sitting above formations that their residents owned but did not know the value of. Formations that the federal government had documented. Formations whose documentation traveled through some pathway that the surviving records do not fully trace. From the survey apparatus to purchasing agents who spent the months between survey completion and survey publication quietly transferring mineral rights from families who did not know what they had to entities that did. Formations that subsequently produced oil that made fortunes whose scale bore no relationship to the agricultural prices paid for the land above them. The geological survey reports are in the National Archives. The property records are in county courthouses across 12 states. The preliminary correspondence that would close the chain is absent from the collections where it should be. The families whose land changed hands in those transactions are gone. Their descendants do not own what is beneath the ground their families once farmed. And nobody with the institutional authority to ask the question has ever been required to explain how the people who bought that land knew what was under it before the people who sold it did.